In Indian polity, we are going to discuss about Article 17 of the Fundamental Rights. So, total articles 12 to 35 which deals about the fundamental rights, and 14 to 32 articles comes under the fundamental rights point of view. Okay, so in this class we are going to discuss about Article 17, that is abolition of untouchability. Okay. So Article 17, it abolishes untouchability and it forbids its practice in any form. Okay, and it is a offense and punishable in accordance with law. Okay, so to give effect to the Article 17, our Parliament enacted one important act. So 8th May 1955, this important act was introduced in Lok Sabha and it was passed in both houses. Okay, so that act is Untouchability Offences Act 1955. Okay, so this was came into force in 1st June 1955. Okay, so and this important act was amended for the first time in 1976 on the basis of one committee, that is Committee on the Untouchability and Economical and Educational Development of SC. Okay, so on the basis of recommendation of this committee, our previous act was changed its name, that is Protection of Civil Rights Act 1955 in 1976 2nd September. Okay, so present we are calling this act is a Protection of Civil Rights Act 1955, and this was amended in 1976 on the recommendations of this committee. Okay, and this committee was set up in 1965 by the Parliament to give more effect to the Untouchability Act. Okay, and coming to the term of the untouchability, basically the meaning or definition of the untouchability or the term exactly is not present in the constitution or in any act of the Parliament. Okay, but we are defining the name untouchability or meaning from the famous or landmark judgments of the Supreme Court or High Court. For example, take Mysore High Court, and it given some guidelines regarding the untouchability. So it given some important subject matter to the Article 17. Okay, so it held that it is not untouchability in its literal or grammatical sense, but the practice as it had developed from historically. Okay, so exact meaning is not a literal or grammatical, but this is a practice from the historical times. Okay, so it defines social disabilities. Overall, untouchability means, and untouchability defines social disabilities. So it was imposed on certain classes of persons on the basis of their birth reasons or their birth regions or their classes or their caste. Okay, and it doesn't cover social boycott of the few individuals or their exclusion from the religious services. Okay, so under the Protection of Civil Rights Act 1955, this is a offensible and punishable. So the person who committed untouchability on the ground of Protection of Civil Rights Act 1955, this is a punishable. So the person has committed the untouchability, so the fine is 500 rupees and 6 months imprisonment. Okay, sometimes both will apply. Okay, and the convicted persons may be disqualified for the elections of the Parliament and state legislature. It means MLA and MP. Okay, and the act, overall act declares preventing any person from entering any place of public worship or from worshipping. Okay, so there is no person prevent any person to enter the public worship areas. Okay, so if any person convicted to this feature, so that particular person will be convicted and punishable. Okay, and justifying untouchability and tradition, religious and philosophical. Okay, and denying access to any shop, hotel, places of public entertainment also. Okay, and so there is no person who there is no person deny any person to enter the shop, hotels. So a person who can go to the shop, hotel, whatever it may be he wants, he can go. So there is no objections to the any person on the basis of their caste or classes. Okay, insulting a person belonging to SC. So insulting a person belonging to lower caste, this is offensible under the Civil Rights Act 1955. Okay, and refusing to admit persons in hospitals, educational institutions, hotels, hostels. Okay, so there is no refusion of persons who are belongs to the untouchability ground, it means backward classes. So they have the access to go to the hospitals and hotels and hostels also. So if any person who refuse the persons for the admission of a hospital something, so that particular person will be convicted under the Civil Rights Protection Act 1955. Okay, and preaching untouchability directly or indirectly. Okay, so there is no person preaching the directly or indirectly untouchability. Okay, so this is also offense under the act. Okay, and refusing to sell goods, render services to any person. So on the basis of SARST, so there is no person who refuses to sell goods or services to the particular person. So this is also offensible under the act. And Supreme Court held that the right under Article 17 is available against private individuals. Okay, so this is very important article from the independence time. Okay, because in that time the untouchability was prevailed. That's why this act was very important in our constitution. It is a constitutional obligation of the state to take necessary steps or actions to ensure or protect rights from the violation. So our state has the responsibility to take necessary steps or actions, okay, to protect the rights of the persons who are violated by the other persons on the basis of Civil Rights Act 1955. Okay.